maulang umaga sa ating lahat. Thank you, Mr. Roderick.
Morning, sir.
Good morning. So I guess we can proceed now, even if I cannot be able to present to you the module. Anyway, we're going to discuss yung topic natin na dapat discuss natin last Monday, which is the Miranda rights. Yan. So we're going to be talking about Miranda rights, in relation to therapeutic modalities. Kasi sabi nga natin, before we can proceed to the different mode of rehabilitation, we should be able to first know the different rights of each and every individual, specifically yung mga PDL natin, or person deprived of their liberty, and as well as those who are undergoing custodial investigation. No? So for this specific discussion, we are going to be talking about rights of person under custodial investigation as provided by the Section 12, Article 3 of the 1987 Philippine Constitution. Okay, so with this, tingnan natin. Well, we know for a fact that Article 3, sino nakakaalam kung ano yung Article 3 ng Philippine Constitution natin? Kung ano yung pinag-uusapan under Article 3 of the Philippine Constitution, I know and I expect that you are all familiar with such provisions of the Philippine Philippine Constitution. I do hope that you are familiar with the provisions of your Bill of Rights. Yan. Kasi the Philippine Constitution, Article 3 specifically discusses the different Bill of Rights. No? Yung mga karapatang pantao natin. Kumbaga, these are the list of the different rights that we have as a Filipino citizens and as a human being. No? So under Section 12, it specifically discusses there the different custodial rights of a person. Section 12 discusses that any person under investigation for the commission of an offense shall have the right to be informed of his right to remain silent, and to have a competent and independent counsel, preferably of his own choice. But if the person cannot afford the services of a counsel, the government will provide one for him. These rights, according to the Philippine Constitution, cannot be waived except in writing and in the presence of a counsel. So what did I just mention? Those are the rights known as the Miranda rights. Yung Miranda rights ng isang individual under custodial investigation na sinasabi at nababanggit natin lagi sa mga discussion natin in relation to human rights, yun yung nandun sa Section 12. Why it's important to uphold these rights of each individual, especially those under custodial investigation, because it is their rights, and failure to inform them of those rights will lead into the invalidation of the arrest, and may result into the dismissal of the case in worst case scenario. So if there are violations being done or conducted by the police officer in relation to the reading of the Miranda rights of those who are being put into custodial investigation, pwedeng maging dahilan yan kung bakit ang isang kaso ay pwedeng mabasura or ma-question. Okay? Ayan. So, under these rights, napakahalaga. Anyway, we are going to discuss the different Miranda rights later on. So, I think we just leave it like that. And now, let's proceed on to the section or paragraph 2 of Section 12. Paragraph 2 of Section 12 talks about torture. Is torture allowed in the police organization, or is torture allowed under the Philippine Constitution? Thus, our Constitution tolerates the commission of torture. Pumapayag ba ang ating konstitusyon, ng ating mga batas sa paggamit ng torture para nang sa ganun ay makakolekta ng mga evidence na pwedeng gamitin sa laban sa isang tao. The answer is of course it's a big no, no? Sabi ng ating constitution in relation to the rights of a person under custodial investigation, no torture, force or violence, threat or intimidation, or any other means which vitiate the free will of a certain person, no, shall be used against him, or even the use of detention places, solitary, incommunicado, other similar forms of detention are also prohibited, no? So yung mga tao na kung saan they're put under the custody of law enforcers should not be tortured, should not be forced, no? Should not be uh, imprisoned in a solitary confinement or in a secret detention places, no? And other similar actions. Hindi sila dapat mag-undergo ng ganon kasi whatever the things that will come out as a result of such activity will of course not be considered as evidence in court and will not be accepted as evidence in court, as well as also a violation of their rights, which means that whoever performs such activity will be criminally responsible or liable for violating the rights of this individual and their basic rights. Okay? So bawal na sa isang police officer na kung saan is torturing niya, pilitin niya na yung isang tao na paaminin sa isang bagay, sa isang krimen, hindi naman niya ginawa. Hindi niya pwedeng gamitin ng puwersa para nang sa ganun ay makakuha siya ng ebidensya na laban sa taong yan. Next is we have here the paragraph 3. This is in relation to paragraph 2. Any confession or admission obtained in violation of this or section 17 hereof shall be inadmissible as evidence. So we made mention of this already, that whatever evidences, information, through admission or confession na makuha ng kapulisan, ng investigator as a result of torture, as a result of force, as a result of violence, as a result of threat or intimidation will be considered as inadmissible. Hindi siya tatanggaping ebidensya. So it's useless, even if sabihin mo, Your Honor, etong taong to, si Mr. Juan de la Cruz ay umamin na siya ang pumatay doon kay Mr. Pedro. However, yun pala ay umamin lang pala si Mr. Juan de la Cruz dahil siya ay tinorture mo. Nilublob mo sa drum, kinoryente mo, tinalian mo yung ari, hinila-hila mo, and whatsoever, if that is the reason why Mr. Juan de la Cruz admitted that he is responsible for the crime, then that could be considered as a violation of his rights under Section 12 of Philippine Constitution, Article 3, and at the same time, that is considered as a criminal offense on your part as a police officer. So that will be the result. Hindi mo na nga mapapakinabangan yung kanyang admission, pwede ka pang makulong or makukulong ka talaga for violating or committing such act. Section 4 states there that the law shall provide for penal and civil sanctions. By the way, why are we discussing these rights? We're talking about custodial investigation. Therefore, in fact, our subject talks about therapeutic modalities. Gusto ko lang din i-clarify kung bakit pinag-uusapan natin ngayon itong mga rights na ito, despite the fact that the subject is related to therapeutic modality. Kasi kung titignan natin, those under custodial investigation will be put into these facilities, confinement facilities. Etong mga taong ito na kung saan is under custodial investigation, dadalhin yan sa mga kulungan sa mga facilities natin. And since they're already being put behind bars, no, dahil sila ay nilalagay na sa mga kulungan natin, uh, the different therapeutic modalities and different rehabilitation programs should already be applied to them, no? Dahil nandiyan na sila sa loob ng ating mga kulungan, dapat itong mga ito is nai-apply na sa kanila, no? I-apply na natin yung mga rehabilitation programs natin, like for example, our programs to education, habang sila ay nandoon sa loob ng kulungan, no? Dahil uh, sir, ano yung relationship? Dahil na isa sa mga tinitignan nating paraan para nang sa ganon we could efficiently rehabilitate a certain individual is, of course, we show care, we show sympathy, we show respect to him as a person. No? Ang isang tao pag sinasaktan mo lalong tumatapang, 'di ba? That's one of the characteristic of Filipino. 'Di ba? Sabi natin kay Andres Bonifacio, no? Habang nasusugatan lalong tumatapang. And at the same time, ganun din ang ating mga kababayan, or ganun din ang isang ordinaryong mamamayan. Kapag siya ay binugbog, no, pinagsamantalahan, inabuso ng ating, let's say for example, mga kapulisan, do you think that those situations, yung mga ganong circumstances will help him in reforming himself as a better, to be a better person, no? Tingin mo kaya makakatulong yun sa pagbabago niya pag pinaranas mo sa kanya yung pang-aabuso, no, pinaranas mo sa kanya yung panlalamang and so on. Hindi, no, hindi. So kahit anong sabihin or gawin nating program sa isang tao na kung saan nakaranas na ng pang-aabuso, mas maliit na yung chance niya na maging effective sa kanya. Now, imaginein mo if meron kang kapatid, no, or meron kang pamangkin, meron kang anak, no, na kung saan is pinalo mo, binugbog mo, and so on, tsaka mo utusan, no? So, tsaka mo pagsabihan, ganun ba yun? Mauna ba yung pagsabi? Kasi, but the point there is that, hindi na makikinig kasi yung focus ng kanyang isip is nandoon na sa nangyari sa kanya, no? Pwedeng na-trauma siya, no? Kaya ngayon, kahit anong rehabilitation program ang i-apply mo sa kanya, hindi na yun magiging effective sa kanya. Kasi nga, ang kanyang pag-iisip, yung kanyang diwa is nandoon nakafocus sa nangyaring pang-aabuso sa kanya, no? Nangyaring pambubugbog sa kanya, and so on, no? So that's the reality with regards to that. Kaya nga bago tayo mag-usap tungkol sa mga programang pangrehabilitasyon, no, para sa kanila, dapat tignan muna natin yung kanilang mga karapatan nang sa ganon ay mas maintindihan natin, no, at mas maprotektahan natin yung kanilang dignidad bilang isang tao, kahit sila ay merong nagawa or sila ay naakusahan na nag-commit ng crime or hindi, no? By having those knowledge, no, about their rights, we can be able to relate, we can be able to assist, we can be able to communicate with them efficiently. Kasi nga, meron tayong common ground. Okay? So that's the thing with regards to that. I'm just justifying the reason na baka sabihin nyo, out of the topic naman si Sir, yan na yung pinag-uusapan niya, hindi naman related yan. Not really. It's not really. They're related. Okay, so we go back to Paragraph 4 of Section 12 of the 1987 Philippine Constitution, Article 3, Bill of Rights. No? Sabi dito, the law shall provide for penal and civil sanctions for violation of this section as well as the compensation. Of course, no? Kung merong violations committed, like for example, there are tortures committed, there are the rights of the accused, the rights of the individual who is subjected to detention, no, who is subjected to a custodial investigation was violated, then it's just appropriate, no, to enforce or to provide civil sanctions, means of payment, penalties, no, for violations, and as well as uh, punishment. Okay? So yung mga nakaranas ng pang-torture, no, victims of torture, victims of coercion and similar acts, no, can file cases, no, can file criminal charges, and at the same time they may require or ask for compensation, monetary compensation for this is to be used, ano, yung mga nakaranas ng pambubugbog ng mga kapulisan natin may ask for monetary compensation, no? Kabayaran para sa kanilang dinanas sa kamay ng ating tagapagpatupad ng batas, and of course that is for the purpose of rehabilitation. Siyempre pang rehabilitate nila yon kasi we expect that if you suffered from such activities, such torture and so on, pwedeng yun yung gamitin or dapat bigyang pansin na kung saan is tawag doon, i-rehabilitate kasi it's expected already that there will be traumas and so on. Okay? Next, custodial investigation. No, pasensya na medyo nahuli itong topic dito compared kanina. Dapat we started with the introduction of custodial investigation. But anyway, what is custodial investigation? Custodial investigation is defined as the questioning, any questioning by law enforcement after a person has been taken into custody or otherwise deprived of his freedom of action in any significant way. So kapag ang isang tao ay naaresto, naaresto na, taken into custody, that's what we mean when we are talking about taken into custody, he is deemed to be taken into custody once he is already arrested for a specific offense, and that could either be that could either be warrantless or with warrant, arrest. So if a person was arrested for a crime, properly arrested or legally arrested for a crime, and the questioning already commences, then that's the start of the custodial questioning. So before the commencement of custodial questioning, bago magsimula ang tinatawag natin custodial questioning, ay dapat mabanggit or maipaliwanag muna sa kanya yung kanyang mga karapatan. Kasi importante na lahat ng sasabihin, lahat ng aksyon ng isang individual who is put under custodial investigation should be proper and legal, and they are in accordance with the laws that we have. Okay, so this investigation, the custodial investigation, refers to the investigation conducted by law enforcement immediately after the arrest. For the commission of an offense, it begins already when the person has been arrested or brought to the custody of law enforcer, in which there is a suspicion that he had committed a crime, that he has something, he holds some significant information towards the solution, towards the resolution of the crime. So yan yung custodial investigation nating tinatawag. So not only that we should be able to define what is custodial investigation, but also we should know what are the rights of a person subjected to custodial investigation. Ano-ano dapat yung mga karapatan na dapat maibigay sa isang tao na maisa-subject into custodial investigation. So first we have the Miranda doctrine, sabi ko nga, dapat ito, alam nyo na. Kasi, this is one of the, how do you call this? One of the important thing that you should be able to memorize not only by your head, but also by your heart. At the same time, if you are an ordinary individual, you should also know these rights, and you should also know that you're entitled of such right. Kasi nga, sometimes abuses comes in kasi uh, abuses comes in because of the people na who don't know their rights, no? Kaya yung kasabihan natin na walang abusado kung walang magpapaabuso, at kaya minsan naabuso ang karamihan dahil hindi nila alam yung kanilang mga karapatan bilang isang individual. So it's important for us to know these different rights of us also in relation to uh, those who have been into custodial investigation. No? But I do hope that time will never come for you to be able to use these things. No? Sana wag dumating yung panahon na kung saan is you are going to use or you are going to request the respect of your Miranda rights and Miranda doctrine. Ibig kong sabihin ay sana ay wag dumating yung time na kung saan is kayo yung inaaresto at kayo yung binabasahan ng Miranda doctrine. Okay? So what is Miranda rights or the Miranda doctrine? No? So the Miranda doctrine, it really means that whatever is initiated or prior to the questioning during the custodial investigation, bago pa man magbato ng tanong yung investigador, ay dapat na nabanggit or nasabi, napaliwanag muna sa kanya, no, doon sa subject of custodial investigation, yung taong naaresto, na siya ay merong mga karapatan. No? At ano-ano yung mga karapatan na yon? Of course, we have the right to remain silent. No? Right to remain silent. What else? Any statement, right to remain silent because any statement he gives may be used as an evidence against him. No? So, meron siyang karapatang manahimik. And at the same time, you as a future police officer should know that, should respect that the subject of custodial investigation has the right to remain silent. Na? So, kapag siya ay tinanong mo, no, at ayaw niyang magsalita, ayaw niyang sumagot, that's his or her right. No? Irespeto mo dapat yun. Kasi, there are other ways, of course, you will learn of the different interrogation technique. Kasi meron tayong mga interrogation technique na ina-apply sa custodial investigation or sa interrogation itself. No? Yun yung gamitin. The legal way of eliciting information through uncooperative subjects. Yun yung dapat pag-aralan mo, hindi yung panonorture, no? Hindi dapat yung kuryentehin kapag ayaw sumagot, kumbaga ayaw umamin, gagamitan mo ng dahas para nasa ganun mapaamin. Hindi pwede yun. Dapat ang gamitin mo since you are learning about the different interrogation techniques which are considered as legal, marami namang techniques na pwedeng i-apply dyan, yun ang dapat pag-aralan at yun ang dapat i-apply. Huwag yung mga considered as a violation of basic human rights and considered as a violation of the laws that we have, our fundamental laws. No? So, we should respect, no? We should respect the rights, especially the right to remain silent, na, by a certain individual subjected to custodial investigation. Okay? So, huwag kayong mabwisit, huwag kayong maasar, huwag kayong magwala kapag ang kinakausap niyong tao, no, ang iniimbestigahan niyong tao, ang inarrest niyong tao, ayaw man lang magsalita. No? Kapag siya ay tinatanong, especially if that's related to the crime or to the case being investigated. Because he is just exercising his right to remain silent. I believe, kung maalala nyo, the case of Napoles before, this was her defense. Imagine that. He went to Senate, no? He went to Senate, he was questioned, he was interrogated, no? He was thrown question that could probably, alam niya, pwedeng makasama sa kanya, no? So, what did she use as a defense, no? She keep on insisting that she has the right against self-incrimination. Therefore, she would like to use his right to remain silent. So, ayan. I invoke my right against self-incrimination. I invoke my right to remain silent. So, yan lang yung mga pinagsasabi niya. Wala silang nakuhang impormasyon because Janet Lim Napoles is under custodial investigation under investigation, no? And at the same time, she has the rights, no? The Miranda rights that protects her from this type of proceedings. No? Whether or not you consider that as whether or not you consider that as a loophole of our judicial system, no? Depende na siguro yan kung paano natin makuha, no, yung impormasyon na gusto nating makuha without violating the rights. No? Kasi me myself believe that well, it may be indeed, no, this may be indeed one of the uh, rights that were created, no, that were created as to protect us from any abuses coming from the government, no, to protect us from any abuses coming from the law enforcers, no, to protect us from any other types of abuses, no. But then you or you may not agree with me that sometimes these different rights that are awarded to those who are subjected to criminal investigation or indeed can be considered sometimes as a loopholes, no, butas, no, na pwedeng lusutan ng mga masasamang tao, ng mga kriminal para nang sa ganun ay sila ay hindi makulong, sila ay hindi mapunta sa alanganing position. Okay? So anyway, with good intention, all of these rights under the Bill of Rights, under the human rights are all made for good intention. Ano? Ginawa itong mga karapatan na ito with good intention and sometimes talagang meron lang yung mga tao na mapagsamantala at sinasamantala itong mga loopholes na ito para nang sa ganun ay makagalaw sila, no? Within the system. They are abusing the system, kumbaga. Okay? So the Bill of Rights, the Miranda rights or Miranda doctrine does not only involve that. No, it has also stipulated that the person subjected to custodial investigation has the right to the presence of an attorney, either retained or appointed. No, so isa pa yan sa napakahalagang rights ng isang individual kapag ikaw ay subjected to criminal or subjected to custodial investigation, dapat ikaw ay meron dapat abogado, no? Huwag kang mag-alala dahil ang isang individual na kung saan ay walang kakayahan na siya ay kumuha ng sarili niyang pribadong abogado ay bibigyan naman ng abogado, no, through the public attorney's office, no? Bibigyan siya ng isang abogado na kung saan is pro-protekta, no, at magpapatibay na yung kanyang karapatan bilang isang tao at bilang isang akusado ay hindi mabaviolate ng ating justice system. Okay? So actually this case the name yung bakit Miranda, no? The name comes from the case US case Miranda versus Arizona, no, wherein Mr. Miranda, no, was arrested and put into trial, no, but one of his defense, no, argued that when Mr. Miranda was arrested, the police officer who arrested him did not explain these different rights, the rights of Mr. Miranda under their Constitution. No? Hindi binanggit ng mga humuling mga pulis sa kanya yung kanyang mga karapatan na dapat niyang malaman doon sa Constitution ng kanilang bansa. Ganyan din sa atin. Ano? That's why now I think the case was dismissed because of such thing, and with that, the Supreme Court, no, their Supreme Court had laid down the principle. No? Nagbaba na sila ng principle na kung saan it mandates the police officers to inform the different rights of a person, no, before after the arrest, no, or before the arrest and so on. Now, so that's the start of the Miranda Doctrine. Ano? Doon na in-honor yung tinatawag nating Miranda Doctrine from that case of Miranda versus the state of Arizona. Now, So under the different rights, we have here yung mga rights of a person during custodial investigation, although we made mention of this already, but I think it's worth repeating. No? Una sa mga sinasabi natin, no, is yung right to be informed of his right. So, it's not only the Miranda rights, no, yung dapat sabihin natin sa kanila. Dapat during the custodial investigation, prior to the questioning, no, dapat ipaliwanag din sa akusado yung kanyang mga iba pang karapatan na isinasaad o binabanggit ng batas natin or ng ating konstitusyon. So, the reading of the Miranda rights or custodial rights by police officer during the arrest will is sufficient, na? To fulfill yung tinatawag nating obligation of the law enforcer on the during the custodial investigation. But you must remember that just reading whatever is written on that Miranda rights, on that Miranda warning, on the Constitution is not enough. Baka naman mamaya in English mong binasa, you have the right to remain silent. Anything you may say can be used against you in any court of law in the Philippines. Sabi mo doon, hindi pa siya nakakaintindi ng English. No? So yung sinasabi nating inform, no, is not mere reading the rights to him. Rather, explaining it, no, to the language or dialect he is known to, no? So kung siya ay hindi naman nakakaintindi ng English, hindi naman nakakaintindi ng Tagalog, hindi naman nakakaintindi ng kung ano mang alam mong dialekto, maghanap ka ng ibang tao na pwedeng magpaliwanag sa kanya, no? Sa mga karapatan niya sa konstitusyon, sa karapatan niya sa batas, no? Sa lengguwaheng naiintindihan niya. So napakahalaga niyan. Kasi baka mamaya sabi mo, Your Honor, I beg to disagree. I informed Mr. Pedro of his constitutional rights. I informed him of his Miranda rights and so on. How could he claim that he was not able, he does not know his rights, and I did not inform it to him? Pwede ang nangyari is that Inglesero ka kasi. Kaya hindi naintindihan ni Mr. Pedro. Yan. So, yung inform, dapat is deep yung kanyang meaning. Dapat nalaman niya talaga. Hindi yung binasa mo lang sa kanya. And it's not reading. It's about explaining it, to the subject of custodial investigation. Okay? Of course, this carries the correlative obligation on the part of the investigator to explain, yan, yung sinasabi natin, and contemplates effective communication with the result in the subject understanding what is being conveyed. So you explain, and then make sure that he understands his rights. Kasi at the end of the Miranda warning, meron tinatawag doon, do you or did you understand your rights? Diba? Tinatanong mo doon kung naintindihan mo ba yung iyong mga karapatan. Pag sinabi niyang hindi, ipaliwanag mo uli. Okay? Next, ano pa yung mga rights niya under the Miranda warning or under the custodial investigation? We have also here the right to remain silent, yung sinasabi natin kanina, the right to remain silent and to be reminded that anything he says can be and will be used against him in any court of laws. Tama po yun, Kapag ikaw ay nasa custodial investigation at ikaw ay nadulas, napaamin, na ikaw ay may kinalaman sa isang krimen, granting that you were informed of your rights, to remain silent, granting na sinabi na sa iyo na hindi mo kinakailangang sagutin lahat ng katanungan ko, sumagot ka pa rin, umamin ka pa rin, that is already considered as either an admission or a confession. And that will be admissible as evidence in court as long as no torture, no force, no violence, or any other trickery that is not allowed by the law was used to obtain such admission or confession. So napakahalaga niyan, Napakahalaga na ipaliwanag na meron siyang karapatang tumangging sumagot or magsalita, kasi lahat ng mababanggit niya no, lahat ng impormasyong babanggitin niya, knowing na hindi niya kailangang sagutin ito, knowing na hindi niya kailangang aminin ito, ay pwedeng gamiting ebidensya laban sa kanya. No? So that only that does not only include yung tinatawag nating verbal confession, ano, yung pag-amin verbally, but also yung mga mechanical acts that does not require the use of intelligence. I mean, there are exemption, no? Kasi kapag meron naman tayo mechanical acts, no? Or under the paragraph B kasi, you are not required to answer any or to answer or comply to any questions or instruction that is being asked to you if that is already considered as self-incriminatory. No? You have the right against self-incrimination. Yung sinasabi ni ni Napoles before, no? Ano ba yung self-incrimination? Ibig sabihin, kung ikaw ay may gagawin na kung saan is magbibigay ka ng impormasyon or ebidensya na pwedeng gamitin laban sa iyo, that is self-incrimination. Like for example, admission, no? Or confession. Umamin ka sa krimen. That's self-incrimination. Kumbaga ginigisa mo yung sarili mo, ano? Na nilalaglag mo yung sarili mo. No? So meron kang karapatan over that if you choose to. No? Pwede kang hindi umamin kasi that's self-incriminatory. Pwede kang hindi magbigay ng informasyon which can be considered as self-incriminatory. The only exemption is that if that is already a mechanical acts, no? Ano ba yung mechanical acts? Meron tayong isang instances na kung saan the identity of the criminal, no, the identity of the suspect of a certain crime of robbery was identified using a pair of a sleeper. No, using a pair of a sleeper. So, doon sa crime scene, merong naiwang isang pares ng tsinelas. So, parang Cinderella. Okay. So, merong naiwang isang pares ng tsinelas. No? At merong witness, the investigator collected the item, yung tsinelas, because it's believed to be an evidence. Kasi basta merong mga bagay-bagay doon sa crime scene na pwedeng merong connection doon sa krimen, pwedeng connection doon sa pagkakakilanlan ng suspect natin, ng criminal natin, ebidensya yan. So, kunin lahat yan. So, he happens to have collected this pair or this single pair, yung isang pares ng tsinelas na yan. Then it happens that some of the witnesses notice that the sleeper, yung tsinelas na yan, is known to be owned by somebody. No? Mayroong makakapagsabi kung sino ang may-ari ng tsinelas na yan. No? At nasan yung pares ng tsinelas na yan. So by using such tsinelas, they trace and they identified the suspect. They related him to the crime, and their evidence was that the pair of sleeper. Una, corroborative evidence, circumstantial evidence, yung isang witness natin nagpapatunay na yon ay pagmamay-ari ni ganito. Second, that we could do is we could try to fit if the sleeper really fits to the suspect. Kung kasya ba yung tsinelas na yan sa suspect. And not only kung kasya, kasi syempre ang sizes is general, But in relation to the, halimbawa sa paa, kasi meron naman tayong podoscopy, meron naman tayong study of that na kung saan pwedeng, di ba, pag matagal mo nang ginagamit yung tsinelas, makikita mo kung saan nabubutas, saan napupudpud una, kasi yun yung may bukol ka sa paa, ganun and whatsoever. So, mga ganong type of evidences. So, what they did was to request yung suspect natin, to isuot yung tsinelas. If it really fits, if those how do you call that, identifying characteristic matches from the foot of the suspect to the sleeper. Now, dito natin pwedeng i-relate yung sinasabi nating exemption to the right to self-incrimination and so on. Question, can the suspect invoke his right against self-incrimination? Pwede niya bang sabihin, ayokong isuot yan. Kasi pag sinuot ko yan at nagkasya, sasabihin niyo sa akin yan. Incriminatory yun. Self-incrimination. I invoke my right to self-incrimination. So, yun yung kanyang sinabi. What if yun yung kanyang sabihin? Is he right? Tama kaya siya? The answer is wrong. No, he is wrong. Kasi under the rules on self-incrimination, that is one of the exemption. Kapag sinabi nating mechanical acts, it's a mechanical act naman yan. It does not require the use of intelligence or to answer a general question. Hindi naman siya sasagot sa tanong, hindi naman siya gagamit na ng utak. All he need to do is to let the officer or investigator isuot sa kanya yung tsinelas and see if it fits. He doesn't need to move if he doesn't wish to move, kumbaga is hayaan niya lang na isukat sa kanya, isuot sa kanyang paa yung tsinelas, So that is one of the exemption. If mga mechanical actions, that does not need the use of intelligence, that does not need the use of your intelligence to perform such act, then definitely that is an exemption. So kung may papasuot sila sa iyo, meron silang kumbaga is isusukat sa iyo and so on, or meron silang iimbestigahan, like for example, they wanted to get your fingerprint, fingerprint, pwede nilang kunin yan, hindi pwede kasi pwede nyo gamitin yung fingerprint ko as an evidence in court. No, that is an exemption to the rules on self-incrimination. Mga mechanical acts yan, kung saan you're just going to let or entrust your fingers to the dactylographer and let him do his job and so on. Blood, for example, hair samples, yung mga physical na ganyan. That is the exemption. Okay? Next, the right to an attorney or to a counsel. A person under custodial investigation has definitely the right to attorney, preferably, sabihin natin preferably, of his own choice, of course, pag own choice mo yan, that is on your own expense din, sa sarili mong bulsa din manggagaling usually yung mga expenses. But in case you don't have the financial capacity to hire, wala ka namang pera na mag-hire ng abogado mo, one will be provided for you by the government. Tandaan nyo yan. Of course, this right is absolute. It applies to anyone. Even if the accused is a lawyer, kahit abogado na siya mismo, kailangan niya pa rin kailangan pa rin i-comply kumbaga ng law enforcer, ng mga investigator natin yung rights niya under this Miranda rights, Baka sabihin mo, hindi na namin siya binigyan ng hindi na namin siya binigyan ng kanyang abogado dahil sabi niya abogado siya Hindi na namin pinaliwanag sa kanya yung kanyang Miranda rights kasi sabi niya abogado siya. Syempre alam niya na yan, basic na sa kanya yan. That's not the case, Hindi ganun 'yun. Kailangan regardless of who he is, what's his job, what's his status and so on, kailangang sabihin, paliwanagan siya ng kanyang mga karapatan. I remember the former president Gloria Macapagal Arroyo, when she was arrested, binasahan pa rin siya of his Miranda rights. However, I think she waived his rights against rights on the Miranda doctrine. Hindi na siya nagpabasa. Pwede naman yun. You can waive your right, but there is in writing. Dapat meron kang sumulat ka prior to your arrest that you are going to waive your rights. Siguro merong mga tulad niya, syempre, dati siyang presidente, masama sa kanyang imahe na kumbaga is binabasahan siya ng kanyang karapatan regarding Miranda Doctrine, or isa siyang kilalang politiko, isa siyang halimbawa is, Pwedeng ang isang abogado, it will be insult, no? It will be, if he consider it as an insult for him to be read, no? Para i-explain sa kanya yung kanyang mga Miranda rights and so on, so he can waive that, no? In writing, dapat meron siyang ginawang kasulatan prior to the arrest, no? Or in the presence of a counsel, no? It's aside from him, no? Pwede rin kasi sabihin, counsel siya, I can waive my right, no? But the process should be followed, no? If that says kailangang merong abogado bago mai-waive yung rights na yan, dapat masunod yan. Okay? Now, what I wanted to talk about this is that yung tinatawag nating competent, independent, and competent counsel. Na? So again, as a subject of custodial investigation, you have the right to choose. No? May karapatan kang pumili kung sino ang gusto mong abogadong magrepresenta sa iyo. If you are going to hire a private attorney, a private lawyer, then definitely that will be at your own expense. But in case you don't have the financial capability, as I've stated, one will be provided for you, but of course you are no longer allowed to choose. Huwag ka nang choosy, libre na nga. However, the government should make sure that the lawyer who will be provided to those who will be seeking the assistance of a lawyer that cannot afford the service of a lawyer will be independent and competent. Yung independent means that he is he is out of biases, wala siyang any personal conflict or interest, wala siyang conflict of interest doon sa akusado at doon sa biktima. Kasi baka mamaya ang binigay sa iyo ng PAW na attorney mo yung kumpare pa ng biktima mo. Di wala yan, may bias yun, talo ka na kapag ganun. So, yun yung iniiwasan, yun yung dapat iwasan ng ating gobyerno. Dapat pag nagbigay sila ng abogado sa mga taong hindi kayang magbayad ng abogado, I make sure that there is no conflict of interest between the assigned lawyer and to the victim or to the accused. Okay? Anyway, those who can benefit from this are those only yung mga akusado. Yung mga, yung mga biktima rather. For the, no. This is only applicable for the accused. Yung mga akusado ang binibigyan ng libreng abogado. Baka sabihin nyo, unfair naman yan sa biktima. For victims, they have the prosecutors. Sa mga biktima, they don't need to hire their own lawyer. Andyan naman yung si piskal. Si piskal ang kanilang tumatayong abogado sa korte. But in case gusto pa nilang magdagdag kasi gusto nilang siguradong makuha ang hustisya, or meron silang kakilala na abogado, or meron silang pera na pwedeng gamitin, so pwede silang magdagdag ng kanilang private lawyer din. But then, the victims of crime does not need to request or does not need to hire a lawyer if they don't have the capacity to hire a lawyer. Kasi ang tatayong abogado ng mga biktima natin ay ang piskal, the prosecutor. Okay? Next is we have here the rights against torture, rights against torture, force, violence, threat, intimidation, or any other means which vitiates the free will of the person. We made mention of this already on the first part of our lecture. Sabi nga natin, lahat ng taong subject to custodial investigation have the rights against torture. This was also stipulated under the Section 12 of the Article 3 Bill of Rights of our Constitution. That anyone who is subjected to custodial investigation shall be protected against torture, force, violence, threat, intimidation, or any other means. So, what's the purpose kasi of the law enforcer kung bakit minsan may nangyayaring torture, may nangyayaring abuses and so on? Why? Confession or admission, Minsan kasi gusto nilang pilitin yung isang tao na umamin sa kasalanan na hindi naman nila ginawa or talagang wala silang kinalaman, gusto nilang paaminin. So that's one of the circumstances kung bakit nagkakaroon tayo ng torture and similar acts, And because of that, now our Constitution had made it clear, and the different laws that we have had made it clear that even if you will be able to get a confession or admission no, from a certain person to a certain crime, kahit mapaamin mo si Mr. Juan de la Cruz, no, kahit mapaamin mo siya, kung yan naman ay naging resulta ng pangbubugbog, pananakot, no, and any other similar acts, then that is useless. Why? Because the court will not receive that as an evidence. Hindi yan tatanggapin ng korte. That is considered as inadmissible evidence. Plus, you can be you can be uh, charged criminally, no? At yung nakolekta mong evidence, no, na ginamit mo, no, na sana pangpakulong kay Mr. Juan de la Cruz, eh baka yan na lang yung gamitin ni Juan de la Cruz na pangpakulong sa iyo bilang isang police officer na nanorture, no, na nananakot, no, at sa pilitang nagpaamin sa kanya. That's the irony. Because you cannot use that as an evidence against him, but he can surely use that as an evidence against you. As an evidence that you had committed, yes, a torture on him. That's why he admitted or confessed those things. Okay? So, yung rights na yan, by the way, that's known as the fruit of a poisonous tree doctrine, ano? Meron tayo kasi yung tinatawag na yung fruit of a poisonous tree doctrine. So, any evidence that will be confiscated or that will be collected in violation of the basic human rights or in relation to not following the right procedure for the conduct of such operation will all be considered as fruit of a poisonous tree. No? At pag sinabing fruit of a poisonous tree, ibig sabihin yan ay hindi katanggap-tanggap na ebidensya dahil yan ay galing sa masama. Okay. So that's the end of our lecture in relation to Miranda warning. I mean Miranda rights in relation to custodial rights, no? Custodial investigation, and some of the provisions of the Article 3, Section 12 of the Philippine Constitution. Okay? So I do hope you learned something from this lecture. Now is your time to ask question. Okay? Meron ba kayong mga tanong? Very sure, eh? Very sure. Okay? So, baka mamaya, ano. Anyway, if you have questions, na, kung meron kayong biglang naalalang, ay, dapat tinanong ko si Sir tungkol dito, ano, don't hesitate to ask, no, kasi we are free naman on, I'm always there to answer questions and queries related to our subject in case there is a need to do, no, so you can just pause or comment that to the group, doon sa group natin, ano, pwede nyong itanong doon, pwede nyong i-comment doon, at kung alam natin yung kasagutan, then definitely sasagutin natin yun. Okay? So, wait lang. So, yung mga hindi pa guys nakapag-download ng ating module, pakitignan nyo lang sa Facebook group natin. Hindi ko rin maalala kung na-upload ko na. Anyway, if there are no more questions then guys, thank you very much for listening, and I do hope meron kayong natutunan. That ends our lecture. See you next meeting. Bye-bye.
Bye, sir.
Thank you. Bye-bye.
Thank you, sir.